rise. And our judgment in the matter of Shilling Property Limited and the Commissioner for Her Majesty's Revenue and Customs.
For the reasons given in the judgment which I am handing down, this appeal will be dismissed. The appellant company will be ordered to pay the respondents' costs to be the subject of detailed assessment if not agreed. There is an application for permission to appeal to the Supreme Court, which we have considered and refused.
Appeal in the matter of the John, administrator of LB Holding Intermediate Limited and Lehman Brothers Holdings Scottish and others.
Yes, Mr. Phillips.
Thank you. Good morning, my lords, my ladies. I want to address you for 15 minutes on three short topics. First is the judge's so what conclusions. Second is 2 points made by my learned friends on intention, one of which specifically addresses the points raised by your lordships yesterday about Mr. Grant's tax sensitivities email. And thirdly, 2 points on outward expression of accord, one which completes an answer that I gave to my Lord Justice Lewison yesterday. So starting with so what, when I left off yesterday, I had been addressing your lordships on the judge's so what conclusion, and the short point is that it is inconsistent with the evidence of both Miss Dolby and Mr. Grant. I showed you yesterday Miss Dolby's evidence that if the effect of the amendments was to alter ranking, then SLP3 would have needed to consider it properly. If I could ask you to take up the judgment, which is at C222, page 431, in relation to Mr. Grant.
Sorry, I'm behind you. CB?
It's in C2, tab 22, my lord. It's the judgment in this. And I wanted to go, if I may, to page 431 and to footnote 229. And it's a footnote to the sentence that you see in D. The point is that no one focused on the question of relative subordination. The point was not raised. And the footnote records it's important to understand the evidence of Mr. Grant in this work. And he refers to a paragraph of Mr. Grant's evidence where he said it was important in making the amendments they did not prejudice the subordination of the subnotes. So I needed to be mindful of that when addressing the tax comments. Simply stating that the solvency condition did not operate on a roundabout would have solved the tax concern, but potentially undermined the subordination. I accept this evidence, but Mr. Grant was referring to the importance of ensuring for regulatory capital purposes that LBHI2 subnotes remain subordinated to the unsubordinated creditors. And with respect, that's not Mr. Grant's evidence. And if I could just take you to Supplemental Bundle 1 at tab 1, page 19.
19.
19, my lady, yes.
Thank you.
And this is Mr. Grant's statement, and he says this: the amendments were intended to refer to the same point in the waterfall as...
Sorry, where are you reading from?
Paragraph 53, my lord.
53, yeah.
Page. The amendments were intended to refer to the same point in the waterfall as the original drafting. There was intended to be no difference in where the LBHI2 subnotes ranked or how much they were paid, whether assessed on a going concern or a gone concern basis. And then over the page, the drafting was intended to preserve the status quo, but used different wording in order to assist the tax analysis. And that is not a statement about the LBHI2 subnotes remaining subordinated to the unsubordinated debt, which is the point that the learned judge took in his judgment. It is a statement about the subnotes staying in the same point in the waterfall for ranking purposes. In Mr. Grant's words, the drafting was intended to preserve the status quo. So that was the so what point. If I may move on to the second point, which is 2 points that arise out of my learned friend's suggestions. If we could just take bundle C1 at tab 8. And if you could go to page 131 and paragraph 92. And it's a point which we've touched on, which is that they rely on what they describe as the commonplace situation where commercial parties are content to agree changes proposed by their lawyers on the understanding that the amendments carry the meaning which the law attributes to them. And in our solution, that cannot be correct where an amendment includes a fundamental legal change the lawyer that the lawyer was not instructed to make, which was never specifically flagged to the client, and which was not intended by the relevant lawyer. But in any event, contrary to PLC's case, Miss Dolby's evidence was not that she would have just gone along with anything that A&O drafted. She would have had to discuss it with her colleagues, and I think I showed that to you yesterday. For your notes, that's at day 3, 91, line 22 to 92, line 8. It's also relevant in the context of Mr. Grant's tax sensitivities email. My Lord Justice Henderson put it to me yesterday, and it's at page 165 of the transcript, that as a result of the tax sensitivities email, the tax issue was sufficiently flagged to the Lehman Group, who did not inquire further into what the amendments had done in relation to unspecified sensitivities, and that Lehman were happy to make necessary changes to address tax sensitivities. And my Lord Justice Lewison said very early in our submissions on rectification that if the wording which was inserted to deal with a particular problem was all removed, then that would leave the particular tax problem unresolved. And my Lord, that was on page 117, but I'm sure your Lordship remembers. There are 3 short points, short but important points that we make in relation to that. The first point is that Ms. Dolby was already satisfied that the notes were tax deductible. This was because PwC had already provided a detailed opinion on the unamended notes and said that Lehman would get their tax deduction. And if I can show you in supplemental bundle 1 at tab 4, this is, and it's at page 56. This is a transcript of an interview conducted by all the parties with Ms. Dolby, which is also referred to in the evidence, but I want to show this to you. And can I pick it up on page 56, which is internal 21 at line 33, where she's talking about the tax deductibility of the notes. And so potentially, but I guess, we would have gone and got a tax opinion on the whole structure before we implemented it. So we would have been happy that we should get a tax deduction from this. So it probably wasn't A&O's call. We would have gone and done our due diligence.
Sorry, I'm behind you. Where are we reading from?
Oh, I'm so sorry, my lord. I started at line 33 on page 56, which is internal 21.
33. Oh, yes.
I'm so sorry. So she says, but I guess not, I guess. We would have gone and got a tax opinion on the whole structure before we implemented it. So we would have been happy that we should get the tax deduction from it. So it probably wasn't A&O's call. We would have gone and done our due diligence on that before we even started the structure sale. And then said, yes, but if there was, we would have gone and spoke. I can't even remember who we used. We know it was PwC. But we would have gone to an external advisor and said, we need a tax deduction for this. They would have gone through, is this equity, is this debt? If it's equity, you don't get a tax deduction. Mr. Lawford then says, I think it was PwC. That would have been done before the LBHR2 subnotes were issued to begin with. Yes, we'd have done all that. We'd have got an opinion before we implemented the structure. And so it's put to her that you wouldn't have asked or wanted A&O to consider that question. A&O weren't my tax advisors. The point is, this wasn't within A&O's remit at all.
Well, does that take you very far? I mean, if it wasn't within A&O's remit, I might have expected Miss Dolby, faced with the grant email, to say, what do you think you're doing? You're not our tax advisors. Why are you changing the wording to deal with tax sensitivities PwC are advising us about tax? But she didn't.
Which comes on to the point I'm about to make, which is that the advice was there was no problem with it, and that's really quite important.
Well, that's another reason why she might have said, why should I accept these amendments? There isn't a problem.
Yes, and in her evidence she says, I can't understand why I didn't pick that up, but I didn't. That was her
Is there a finding that there was no tax problem?
No, but I'm about to explain that to you.
Sorry, there is a further point, isn't there? Which is, I mean, A&O are obviously highly experienced solicitors, so whatever the precise scope of their remit, I mean, if they perceive there is a potential tax problem, I mean, surely it's only natural and indeed right and proper that we should draw attention to it.
Yes, and you've seen the evidence in relation to the limited. It was very limited. They didn't explain it. They didn't.
Well, I mean, it all seems to have gone slightly by default. I mean, it seems unfair to me to criticise them for actually raising a point, which obviously was taken by them in good faith.
And it was a non-point, which is the point that I'm about to deal with. So the points that you need to bear in mind, and this is with respect, this is important, is number one, Lehman thought these notes were tax deductible. They had advice from PwC that these notes were tax deductible. Number two, these were
in their unamended form.
In their unamended form, my lord, yes. And when I get to point 5 on this, I'll draw something important out of it. These were not necessary amendments from Lehman's perspective at all. They were not intended. They were not intended to make changes to drafting. It was only to preserve and reinforce the status quo. You've seen that from Mr. Grant's evidence. They did not, in fact, make changes to the tax status. And in light of that, if the wording were removed, it would have no substantive effect on the tax position, and there would be no tax problem left unresolved, which goes back to my Lord Justice Lewison's question at the start. The tax problem was illusory, it wasn't real. And this is the final point. If that tax problem was real, it exists and existed in relation to every standard form subordinated debt used for capital purposes. It existed on every standard form that used conditionality, which of course you've seen and you know they all did.
What was the point that the tax problem was illusory? You argued before the judge. Did you make any findings about that?
No, and one of the reasons for that is it's very much a question that's come up. Your Lordship.
Well, how can we decide without...
Because it's not doing this experiment in 15 minutes. This was not argued for the judge. Furthermore, it's not in notice of appeal. I don't think there's any evidence for the court about it at all, and it's a total surprise to me. So I'm not quite sure what the court.
Well, I'm surprised my learned friend is surprised, but your Lordship asked the question. This is the answer to the question. So your Lordship asked the question, you would leave a tax problem unresolved.
Well,
the answer to that question is no, you wouldn't.
Well, I'm not sure that we can just brush it aside like that without either any evidence or any finding.
Well, my lord, I've given you the materials.
All right.
And your lordships will deal with the materials, but I was responding directly to a
all right.
question
Yeah, I
which your
understand.
lordship asked. Because the point that I wouldn't want your lordships to have in mind is that there is a tax problem that would be left unresolved if we took the language out.
Well, I mean, there was a perceived tax problem. I think that's really as far as we can take it, isn't it? I mean, you say there was no substance to it. And it's not for us to begin doing an independent investigation of our own bat as to the merits of a point.
No, I understand, my lord. And what I can say in relation to that is Mr. Dayhell perceived there was a tax problem. And Allen and Overy did not know, and there is evidence to this effect, Allen and Overy did not know that PwC had already advised on the tax issue.
I have to say that I'm still slightly lost about the effect that has on the intention of Lehman's and Miss Dolby, because she received that email from Mr. Grant and saw what was in it, and everyone proceeded on the basis of the draft. So they intended the wording which was inserted.
My lady, with respect, that's putting it too high, because you have got Jackie Dolby's direct evidence of what all she was intending to do was to defer the interest. You've seen that massive evidence, and I'm not going to repeat it all.
Yeah, well, I think we've got your points on that.
Exactly, I think you have the point. So can I just deal with the second point, because I'm sorry that just took me slightly out of PLC and Deutsche Bank both say that the mistake is not one of legal effect, but one of commercial consequences. And I'll just make three short points. The distinction between legal rights and commercial consequences is very clear from the case law, and I won't take you to FSH. Secondly, on the judge's finding and on PLC's argument, the effect of the amendments was to subordinate the debts to all debts, including U2 debts, save for the debts using the preference share mechanism. We went through that yesterday, and that is a significant legal change. That is not a commercial consequence. And I'll also just remind you, the third point is remind you of AMP. Rectification may still be available even if the parties have quite deliberately used the wording in the instrument, and one must not lose sight of that point. Yes, there was wording in the instrument. Yes, there was a reference to tax sensitivities, but against all the other material, we would respectfully submit that doesn't take you to the point where you say, well, they just said, we will accept this language, and it's the commercial consequences of that language. Can I then just deal with outward expression of accord? And you'll have picked up from the judgment in paragraph 268, his conclusion flowed from his finding that there was no subjective continuing common intention, and we say the judge erred in two respects. First, he was wrong to find there was a requirement to prove an outward expression of accord, and secondly, even if there was such a requirement, we say it's made out on the facts. No requirement for outward intention. Your lordships are familiar with the pensions cases. Where an agreement is being amended by a mechanism, consensus or consent suffices, and there is no need for an outward expression of accord. And your lordships have AMP for your notes in 64 to 66. That deals with converging intention as sufficing in pensions cases. I showed your lordships condition 12A of the notes yesterday, and we say that that brings this case in line with the pensions cases. Now, there's one point of correction of myself. My Lord Justice Lewison asked whether the amendments could be made in whatever form, your lordship will remember, from the issuer, with the consent of 100% of the note holders. And in my answer, I referred to the fact that they were listed, which you'll see in 146
Yes.
of the transfer. That answer was incomplete, and I should have made the more important point, which is these notes were regulatory debt, and with LT2 status, and they could only be amended with the FSA's consent. And there are two documents, if I may just show you. The first is in supplemental bundle 2, tab 35. Which is on page 501.
S2 35.
Yes, my lord. Page 501. And what this is the LT2 opinion in the amended amended June 2008 notes. It refers to the original opinion, and if I can just show you the second paragraph, at the time of the issue of the notes, you asked us to confirm whether the notes qualify for inclusion as lower tier 2 capital resources under GEM-proof. We provided this confirmation in a letter to you dated the 1st of May, and then 2 down, on the basis, I should carry on. You intend to procure the amendment to allow the issuer to defer payments on the notes. Following such amendment, the conditions will be in or substantially in the form of Annex 1. On the basis of foregoing, we confirm the confirmations provided in the original letter will continue in full force and effect in relation to the notes after the amendment. And then if you could just go forward to tab 39, which is the emails passing between Lehman's and the FSA on this point. It's on page 516. And starting at the bottom, Mr. Edgley of the FSA says, we confirm that there's no reason for us to object to this change in the terms of lower tier 2 instrument. Up one email, Claire Edwards of Lehman's thanks him and says, you asked for a little more detail on the rationale for making the change to the terms. The change to the terms of the notes is designed to provide Lehman's with flexibility around its US tax planning. So I'm not sure I made that clear. The tax problem that they were deferring interest for was a US tax planning point. Tax purposes, any deferral of the cash payment of interest on the notes will result in tax deduction for interest being deferred until the cash payment is actually made. This is purely a US tax planning initiative. It have no net impact on UK tax. You can see there is Lehman's telling the FSA they did not intend to have any UK tax impact. And then, so that is a more important. If they wanted it to remain LT2 debt, they would always have needed the FSA's consent. And of course, you know there's a history of the standard forms which could be amended with consent.
Yes, I mean, I think the question I think I asked you was whether they could agree as a matter of contract.
As a matter of contract, absolutely, my lord, yes. But in the context of regulatory LT2 debt, there are constraints. Finally, on outward expression on the facts, we've addressed it in our skeleton. Can I just make 2 short points because I haven't covered it? The intention only to defer the date for payment of interest was communicated through the Lehman Group and to third parties. And your lordships have seen the evidence of Miss Dolby, of her discussions with Mr. Rush, her correspondence with Mr. Triolo. We also say that it is significant that the same individuals in the cross-departmental group, including Miss Dolby, acted on both sides of the transaction, such that what was known by one party was also known by the other party, and therefore communicated between them, which is how intention and knowledge cross the line, if of course it is necessary for us to show that it did. You've got the other point. Finally, and then I will sit down, may I answer your lordship's question on Mr. Justice David Richards. You asked me the question, transcript page 33, and the answer in terms of page references of where Mr. Justice David Richards dealt with the point is paragraph 65 to 69 of Waterfall 1. But I want to show you paragraph 122 of the learned judge in this case's judgment, which is C2 22 at page 381, because he explains that it is the subordination that means you cannot prove until after the senior debts, and you do not, it does not turn on whether you have got a clause like clause 7. So do you mind if I just show your lordships the judge's reasoning because we respectfully agree with the learned judge.
Para 122.
122, subparagraph 2. And what the learned judge, what he said was, both David Richard and the Supreme Court held that the reason the proof could not be lodged by the subordinated creditor was because that would breach the terms of the agreement between the debtor and the subordinated creditor. He then refers to clause 7, which is the point your lordship was making to me, of the agreement before the court's provision that may or may not, and that's important, be replicated in other subordination agreements. However, as it seems to me, where there is a provision actually subordinating a debt, i.e. a case of simple contractual subordination, then such a provision must be stating that the subordinated debt itself ranks below other obligations that would ordinarily themselves be below it in the legal waterfall. It would render such a subordination provision entirely futile if, contrary to the subordination provision, the subordinated creditor nevertheless proved. It therefore seems to me that any effective clause of this kind subordinating one obligation to another must render the creditor unable to prove, at least until the obligations prior to that debt have been satisfied in full. And with respect, that is entirely right, and it flows not least from the fact that they are subordinated, that it is the right to payment that is subordinated, and in a liquidation, the right to payment is and can only be the right to prove.
Yes.
My lords, I have gone over my time. I apologise, I did try. Unless your lordships have any further questions, those are...
Thank you very much,
Thank you
Mr.
very much.
Lord, the terms are available. Structure, just to indicate where I'm going. First, I've got a few introductory comments. Then I want to say something about the subordination analysis in general. Then ranking by reference to the amended notes. Then go back and forth to ranking by reference to the unamended notes, and then rectification. So that's the sequence. I think that's pretty much following Phillips did too. Introductory comments, and some straightforward, some first and obviously, the issue between Mr. Phillips and myself is the relative ranking of these two instruments. That is an issue of contractual interpretation and contractual application, and slightly different, as we'll see, which all the normal rules apply, and there's no credible suggestion the judge made an error in his approach to interpretation or application. Second, there's no special rule for interpreting an amended agreement. The task is to interpret the agreement as at the date was concluded, namely the date of the amendment. And that is straightforward too. However, I mention that because it's wrong to approach the question, and at trial, and to some extent yesterday, Mr. Phillips sought to approach the question by construing the pre-existing contract and asking was there an intent to change it. That is the wrong approach, because that leads into subject to intention, into factual matrix problems, etc. One has to construe this agreement on its face as at the date of the amendment, without a prior assumption as to what the pre-existing contract did, or what its intention was in relation to it. Third, these contracts ought to be interpreted largely by their words and the contractual context, rather than by reference to any wider factual matrix. As your lordship and ladyship will now be aware, the sub-debt agreements took a standard regulatory form pursuant to the I-Prove-In rules, which required sub-debt agreements to have a fixed term. It's in the bundle, we don't have to turn it up, but there were standard forms, and these were those standard forms under Rule 10. So the scope for factual matrix is inherently attenuated for a standard form agreement. Equally, so far as the subnotes are concerned, by the time the subnotes came to be created in 2007, I-Prove-In had been replaced by whatever all the acronyms, GenProve. And under GenProve, the General Prudential Source Book, no standard form was required. They did away with standard forms. All that was required was that the content sufficed to satisfy GenProve. We don't need to turn up the details for that, because that's, I think, common ground. In fact, and this was explored in the evidence, the precise scope of the template for the the subnotes was never identified. Nevertheless, by their terms, they were transferable to third parties, and therefore, as Lord Justice Lewison indicated yesterday, that in itself also narrows down necessarily the scope of factual matrix in relation to those contracts. SLP3 has maintained the case, as they put it, that there was never any intention to transfer the notes out of Lehman, but as I think the discussion went yesterday, that's a resort, on the face of it, probably it's subject to intent, it's certainly a resort to factual matrix, and it's not, we submit, relevant to this question, which is these notes have to be construed, and working out how to construe the notes, one has to see on the face what they objectively said. Objectively, these were negotiable instruments, and therefore one has to construe them as such, and therefore the scope of factual matrix is necessarily limited because of that objective analysis. In fact, for what it's worth, and I won't go to the detail, the evidence supporting the idea that there wasn't any intention to transfer out of the Lehman Group was rather thinner than has been suggested. The evidence, in fact, was there's no present intention to transfer out of the Lehman Group. Ms. Hutchison indicated that there were tax considerations every day of the week, frankly, in Lehman, and one day you might do one thing, the next day you might do something else. So it was only at best a present intention to keep it within the Lehman Group, but no one would know what would happen in the future, what tax ways would have been identified for those days. It didn't happen either. So the evidence is rather limited anyway, but it's not, we submit as a matter of law, relevant. The fourth introductory point, there's a lot of focus at trial and yesterday, or some focus yesterday, on the regulatory position. And we do accept that the regulatory position is in theory factual matrix for the construction of these instruments, because they were issued in the context of the regulatory regime. So in theory, that is an exception to factual matrix in that in theory it's available. However, the only relevance of the regulatory position in this case to the ranking issue between these parties is that the regulatory regime was not concerned at all with relative ranking of subordinated debt. That was a finding of the judge, paragraph 61 C of his judgment. He noted, as far as the regulator was concerned, this was not an issue. The regulator's concern was that all subordinated debt be subordinated to all unsubordinated debt. And one can see that.
Well, you've got that finding.
We've got that finding. So it was no part of the regime to specify layers of regulatory findings, and therefore there was no requirement or preference of pari passu as a matter of regulation. Yesterday, Mr. Phillips made reference, you'll remember, to the Basel working paper, which made a passing reference to pari passu. It didn't really explain in respect what he sought to derive from it. There's no evidential case in relation to that. There's no context for it, and just as a document, what it says for what it says. And there's no challenge to the judge's finding about the regulatory position. It wasn't transferred into Gen Crew that there was any pari passu preference. So whatever the Basel working paper may or may not have said about pari passu, for whatever reason and whatever it meant, doesn't dislodge the primary position, which is as a matter of regulation, this is not a relevant consideration. The fifth introductory point is that SLP3 has sought at trial and on appeal to place reliance on a supposed market expectation or custom of pari passu ranking between regulatory capital at the same tier.
I don't think it's put as high as custom in the legal sense of it.
Well, some form of expectation, I think, is certainly
certain notorious, etc., etc. You need to show for custom.
Yes, I don't. Maybe even they can't go that high, perhaps. But there's been some. It's sought to be suggested that there's some relevance in a market expectation of pari passu. The judge made no reference to that, and he was perfectly, we say right, he was certainly entitled to do so. It derives, as far as it derives at all, from the evidence of Mr. Miller, which I'll take you to in a second. But the background to that is that SLP3 had asserted some form of market practice in support of pari passu distribution in its position paper. So there was an origin to this point. There weren't pleadings in this case, there were position papers which took the form of essentially pleadings a bit fuller. If you can turn up core bundle 2, please, page 525. It's paragraph 24.6.2. This is the SLP3 position paper, and that's subparagraph 6, Roman 3. It was asserted regulatory context and market practice. This is a base obligation. So no regulatory.
525.
525.
Oh yes, got it.
6.2. And then I think it's mainly the second sentence, no regulatory need for one instrument to rank differently from another, which is the reverse point of there's no regulatory concern about it. An ordinary market practice was for dated subordinated debts to rank pari passu. So they kicked off with an assertion of practice. The response to that, sorry to take this through the Silverado one, if you go to 642, which is tab 62. This is the PLC response. 48. 6D.
Where are we now? 642.
642.
Maybe the wrong reference.
Maybe the wrong reference. Sorry, paragraph 6. Sorry, one. Sorry, 6D. I shall maybe figure the difference if necessary, but in any event, the response was that submission would need expert evidence if you were going to advance it. I'm given 560.
560.
560.
So we're in a different document.
Yes, I do apologize for that. This is our position paper. 560. 6D is where we said this would require expert evidence. Reserve divisions, we see admissible evidence. And we don't need to go through the next reference. SLP3, when it came to the CMC, expressly declined to seek expert evidence. We said we're not seeking expert evidence on that point. So there was no order for expert evidence in relation to it. What then happened is that Mr. Miller was called as a witness of fact. He had been involved in the drafting of the notes. He was called a witness of fact. In fact, most of his evidence is inadmissible anyway, but he was called a witness of fact. And he was the one who spoke of some form of expectation about pari passu. And that's why we submit the judge was right not to take into account when he said to the judge, this is purported expert evidence, which isn't expert evidence, it is opinion evidence, isn't evidence that you can properly give. In any event, what he actually said was, again, rather weaker than is being asserted. If you go, please, sorry to go to the next bundle, supplemental bundle 2, tab 53. Page 5. 159, top left quartile, page 21, and you see letter 18 for the judge's question. To be clear, the last sentence is a description of the default that would pertain absent a contract provision in the instrument. That would be right. That would be the convention or default setting. And then if you go down to the left-hand quartile from letter 12, Ms. Hilliard is asking, what you were saying, Mr. Miller, as far as you are concerned, you would expect instruments with lower tier 2 and 3 to rank pari passu. As a general matter, yes. But you'd also accept that ultimately it depends on the terms of the agreement itself, doesn't it? Yes, yes, it does. So what he was saying, that's what I'm effectively saying, is it depends in terms of the contract. So Luke submitted, it doesn't again help that evidence, even if admissible, and even if the judge wrongly didn't give regard to it, it wouldn't help really in terms of a factual matrix. Now, the sixth introductory submission is that a focus of SLP3's case is on Insolvency Rules 1412, the pari passu principle. And to be clear, we do not seek to diminish the importance of that principle in the insolvency regime. We accept that that's the default rule, and whether you say it's a starting point and the end point is a matter of terminology. Here it's the default rule absent a contractual provision to the contrary. And we accept, as per Golden Key, which Mr. Phillips took you to, that the existence of the rule may be said in some sense to be part of factual nature. But the judge found the contracts displaced the pari passu rule. And we submit he was right to do so. We never actually get to the pari passu rule, but as a matter of contractual interpretation, that was displaced. And where we take issue with SLP3 on this point is their attempt to elevate the pari passu rule into some form of principle of construction. The way it's put in my friend Skeleton, we don't need to turn it up at paragraph 47, he says, in the absence of clear and unequivocal language to the contrary, the judge should have applied the default rule. And that, we submit, puts the matter far too high. There's no such principle of interpretation that requires, quote, clear and unequivocal language to place pari passu. The rule simply yields to contrary intent, and one can see it.
I think that's what Lady Justice Arden said in Golden Key. Does it evince a different intent? Yes,
exactly, and that's the question. So one doesn't get a leg up, if you like, by the existence of the rule unless you interpret the contract. Now, the sixth point, SLP3 also focused throughout the argument on on a question as to whether and when a creditor can prove the debt. We accept also, don't seem to diminish that the proof of debt process is a necessary part of an insolvency regime. We also accept that in some priority disputes, it may matter whether a debt is provable, and if so, when. And a prime example of that, as we'll have to look at, I'm afraid, is Waterfall 1, where it mattered. It doesn't matter here. The issue here is between the relative ranking of two provable debts as a matter of contract. The outcome of that ranking issue may or may not have an impact on when the debts can be proved. That's a matter of insolvency process at the next stage. What you can't do is answer the ranking issue by trying to ask when the debt can be proved, because you're going the wrong way around. This issue is not an insolvency issue per se, it's a contractual issue. So those are my introductory points. If I can now move on to the subordination analysis, and perhaps pick up, if we can, go back to the judgment, core bundle 2, tab 22, page 368. This identifies what he regards as three mechanisms to achieve subordination: trust subordination, contingent debt subordination, and simple contractual subordination. As a description of common mechanisms by which subordination can be effected, this was, we say, uncontroversial and plainly right. It accords with the analysis that we see in Fuller. If you
Is that the quotation at paragraph 88?
There's rather more to it in the actual judgment, in the actual passage itself. If we can just pick up the authority.
Right.
Authorities bundle 4, tab 70, 2359.
470.
Yeah. 2359. And what Mr. Fuller explains, 1156 speaks of contingent debt subordination. You can see that. But more significantly, as we'll see going through, he identifies two ways to achieve what he calls contingent debt subordination. The junior creditor agreeing that in a winding up, he is only entitled to what he would have received had he been the holder of a first-ranking preference share. That's the preference share mechanism. And the second mechanism is a solvency test. Taking account the senior debt and any other subordinated debt intended to rank ahead of the junior debt, but excluding the junior debt, or a combination of the two. So the two potential mechanisms to achieve equal contingent debt subordination, the preference share mechanism and the insolvency mechanism. And if you go down to 1158, go to the page, says there do not appear to be any cases specifically upholding the validity of contingent debt subordination. Thus, trust subordination and simple contractual have both been held valid. It seems inconceivable that contingent debt subordination is not also valid. So that's what Fuller said about mechanisms, and it's also consistent, we say, with what my Lord Justice Lewison said in Waterfall 1. Apologies for jumping around again. Authorities bundle 3, tab 53, page 160. This is paragraph 38.
Sorry, so page
1603.
Thank you.
Paragraph 38. And clearly anything we say is with reference to my lord. But as we read paragraph 38, what your lordship was doing was merely setting out mechanisms by which subordination could be achieved.
Yes.
Including in the second one, the right to repayment as being contingent on the satisfaction of a condition or conditions. So the judge picked up Fuller and your lordship's descriptions of how you can do it, which is, in our submission, not controversial. Now, it's important to appreciate there's no particular magic or significance to various categorizations identified by the judge. And there's no special words required to achieve subordination. And nor are the categories necessarily mutually inconsistent. In a sense, they're all contractual. They all have a contractual bit. So there's no real magic to any of that. They're merely contractual methods by which the outcome of subordination can be achieved. There's no reason why it can't be done, provided it doesn't interfere with any policy. Of course, there was a debate as to whether it did interfere with the policy before, but that debate has been resolved after Maxwell and subsequent cases. And that's why we submit that your lordship's descriptions in paragraph 38 aren't controversial, and we don't understand SLP3 to be challenging them as descriptions of methods, and in particular that subordination can be effected by conditionality tests. We don't understand that to be an issue. Now, one possible error from the judge, as we've indicated in our Henderson, having set out the various categories, is that he may have treated the categories as rather too rigid. Because, as we know, he decided that, by reference, for example, to clause 5.1 of the subtext, there were two distinct forms of subordination within the single clause, what he called simple contractual and and he saw them as distinct, and he interpreted the word accordingly, meaning and also, or in addition, so there were two. And that, we say it's not impossible to end up there, but it's a rather uncomfortable conclusion. It appears to be an unlikely conclusion, because you may end up with two potentially inconsistent subordination clauses in the same agreement. And therefore they might produce different and inconsistent ranking outcomes. Therefore the better approach as a matter of interpretation is to strive for a single subordination division to that clause as more likely to reflect the commercial intent, because conflicting subordination divisions is not likely to reflect the commercial intent. Now,
I think yesterday Mr. Phillips said that accordingly meant in consequence, or something along those lines.
Your Lordship put to him that it meant in consequence, and he said, yes. Well, that's in fact what we say it means. I'll explain that in a minute. But we're happy with in consequence. In terms of how you interpret this clause, it doesn't, in a sense, really matter how it's achieved, provided the clause is applied as a whole. And what it means critically, and this, I think, is the big difference, one of the big differences between us, is that the application of the conditions may themselves inform the content of the definitions. You don't go for the definitions, find your answer, and then say, well, do the solvency conditions affect that? You apply them together such that the application of the conditions itself informs or may inform the definition. Now, as to how to achieve that, we submit, and we may have to, maybe it's best to pull it up just to know your Lordship. I've seen it probably too often already, but it's bundle CV, core bundle 3, tab 38, page 678.
Page
678. You can do it by reference to this one.
Yeah.
But what we submit is that the better approach, starting from the position one has to read them as a whole, is to read the first clause, i.e. the bit, the rights of the lender are subordinated to the senior liabilities accordingly, before you get to accordingly, as, in a sense, confirmation that the debt is subordinated debt, which is important for regulatory purposes, of course, but that has to be the starting point. That is the intent. These are going to be subordinated instruments. And the second clause after accordingly is the mechanism by which that subordination is achieved. And what the mechanism does is it lays out a practical test which can be applied whenever a payment comes to be made, in order to see whether it can be made in priority to other payments. And that is, of course, one of the fuller contingencies we looked at. Exactly the way he identified. And that is why we read accordingly. Well, we suggest that, and therefore, but I think in consequence, it is essentially the same. The statement, I think the Lord should put it this way, or one of you Lord should put it this way. There's a general principle and the consequences. And that's what we say works here. The general principle of subordination and the mechanism to implement it. Now, it's also consistent, we say, with the way these provisions have been considered, or at least have been commented on. If we can go back, please, to the authorities bundle, you may have to keep out volume 3, because that's what the agreement is. If we can go back to authorities bundle 3, tab 54, page 1662. So tab 54. this is, just so you had a case before, so another Lehman Brothers, one of the many Lehman Brothers debates. This was my Lord Justice Henderson, as it was. Again, considering the same instrument that has been before the court a number of times. But if you go to 1662, I don't think I can hold your lordship to this because I don't think it really matters for the purpose of the case, but just the way it's expressed is consistent, we say, with the way that it ought to be expressed. If you go to paragraph 17 at the bottom of that page, having set out the provisions, clause 5.1, what your lordship says, in order to give effect to the principle of subordination, payment of any amount by LB UKH in respect of the loan is then made conditional upon matters set out in subparagraph. So it's, yes, I don't know if I can hold your lordship to it.
Well, I don't recollect there being any issue about
No,
the point.
exactly.
That was really my attempt to express in words what I think I understood from a reading of the clause, which very much accords with how you're putting it. As it happens.
That's the only reason I put it there.
Yes.
But we would say it's the natural way, one accepts, one reads it together. It's the natural way to put the two together, the statement of intent, and then the mechanism gives effect to that statement. And that we say is legitimate and appropriate. So, Mr. Phillips said yesterday, PLC attached no weight to the definitional wording. And he also said that on our case, conditionalities have a freestanding effect regardless of the definitional wording. Neither is correct, to be clear. We're not seeking to avoid the definition. The definitions are clearly part of the clause. But we are seeking to apply the definitions by reference to the mechanism. And that's where they interact. Now, having sought to give your lordship a roadmap of how to approach the clause, I'm afraid I have to deal with the point of, we say, complete irrelevance to your lordship, but as such a long time has been spent on it, as before the judge, I have to do it. I don't read it. It was pushed before the judge and the Court of Appeal. Frankly, we don't think we're on the same battlefield here. That's the relevance in this case of Waterfall 1. We submit Mr. Justice David Rick's judgment has a background relevance insofar as it sets out the regulatory position, and therefore that's of great interest in terms of the background even to this case. The Court of Appeal judgment, the Federal Lord, has relevance in describing those mechanisms of subordination, paragraph 38. Other than that, we submit there's nothing of any assistance in Waterfall 1, because the issues in that case are entirely different. At the end of Mr. exposition of the various cases, as if you like, the conclusion, he submitted yesterday that the Supreme Court had decided that clause 5.1b of the subject agreement does not create a contingent debt. That was the also may recollect, I think, where we got to after the exposition. Now, we submit that's wrong, or at least it's not what the Supreme Court actually decided. But to be clear, we advance no case as to whether or not these were, quote, contingent debts. That is a concept relevant to insolvency, which may have a relevance to timing of proofs, may have relevance to value of proofs. Those are the issues. It's a term of art, which is a relevance in the insolvency context. It has no relevance to the contractual ranking issue. SLP3 don't deny that subordination can be achieved by conditionality. So whether ultimately the conclusion is you can describe this as a contingent debt or not, is again the next stage, not this stage. The argument really goes no further, we submit, than Mr. Justice final in Maxwell. And if I can ask you to turn up please, Authorities Bundle 1, tab 17, page 317. Page 317, and you recollect, your Lordships and Ladyship will recollect from yesterday that this was the first case which gave the green light for subordination provisions. 317 letter G, having gone through the cases, Mr. Justice Beaumont said, I have some doubt whether in English law a subordinated debt is accurately described as a contingent liability. And that comes from the South African case of Ex-Parte. So again, he's talking about the term of art, whether, if you do have a subordinated debt, whether you get into that particular term. Next paragraph below letter H, however, nothing turns on the question whether a subordinated debt is aptly described as a contingent claim, an essential feature pointed by Justice Goldstone, and he talks about a debt payable to the extent of surplus after meeting a payment or other unsubordinated creditors. The same applies here, my lords and ladies. Nothing turns in this case on whether either of these debts is accurately described as a contingent debt or not. The only question is, what's the priority of these debts? Now, let me just say, just 5 minutes on Waterfall 1, and just suggest what that was about and why, what was that was about. In Waterfall 1, the timing, the timing of the proof was, unlike this case, a potentially relevant issue. And that was because the priority issue was entirely different. It wasn't a matter of contractual ranking between two subordinated debts, as between a subordinated debt on the one hand and different categories of debt, namely statutory interest and non-provable debt. And that gave rise to an issue as to the waterfall, because if we can go to Waterfall 1, David Richler's Authorities Bundle 3 at 51, page 1480. This is David Richards, this is Justice David Richards' judgment, Waterfall 1, paragraph 13. He sets out the waterfall from water. And one can immediately see, and the issue arose between 5, 6, and 7. Because number 5 in the waterfall is unsecured provable debt, 6 statutory interest, and 7 non-provable liabilities. And the real question was whether these subordinated debts were unsecured provable debts, in which case it came out number 5, or whether they were themselves subordinated to the statutory interest and non-provable liabilities. But one can easily see why provable was a relevant point there, because on the face of the waterfall, if it was provable, it came in at number 5. Of course, the decision was it didn't. It came in at number 7 or 8 or 9 or whatever. But that was the context of the debate in Waterfall 1 as to the need to determine the question of provability. And the argument from the creditor's point of view is that because it was provable, it should go ahead of 6 and 7. They also relied, in addition to relying upon the waterfall, they also relied upon Insolvency Rules 2.887. You go to 1481, the next page. 1481, letter C. This is the provision in the Insolvency Rules. There's something similar in the Act on section 189 in relation to winding up. But 2.887 on the face of it says, this is in relation to statutory interest, any surplus remaining after payment of the debts proved shall, before being applied for any purpose, be applied in paying interest. So again, on the face of it, statutory interest arose after payment of the debts proved. So again, the creditor says, well, there you are. It must come after these debts, even though they were subordinated. So these were the more technical requirements that gave rise to the provability of the question. As to the ranking itself, there were various construction issues on clause 5.1, precisely what the solvency condition meant and didn't mean, and that had to be resolved. But the relevant bit for our purposes, I think, if you go to paragraph 54 in this judgment, is that Mr. Justice David Richler also referred to clauses 7, 7D and 7E of the subject agreement. And clause 7D said that the creditor couldn't attempt to obtain repayment otherwise in accordance with the terms of the agreement. And E couldn't take or omit to take action whereby the subordination of the subordinated liabilities might be terminated, impaired, or adversely affected. So that was thought to be, as it turned out to be, a very relevant point, as we'll see. If you go to 58.
This is in the Supreme Court now.
No, still in this judgment.
Oh, I see. Paragraph 58. Yeah.
Paragraph 58 and then 59. This is the arguments available. If you go 59, about 6 lines down, the relevant provisions of the applicable insolvency regime are for present purposes the provision of insolvency rules, the proof of debt, and the provision of Rule 2.88 as they apply to statutory interest. And that was the point being raised in relation to 2.88. But the answer to that, and the answer to the waterfall point as well, as given by Mr. Justice David Rich in paragraph 68 on page 1491. I do not consider the terms of Rule 2.88 in section 189, that's the winding up equivalent, where the support for Mr. Trace and Mr. Isaacs contend, sets it all out. And then 69, the answer to this point that Mr. Triad, the administrator, submits the provision of 7D and E. The expression of debt proof means all those debts submitted to proof, only those debts were paid out of the available assets. In my judgment, the lodging of that proof in respect of the subordinated loan, coupled with attempt to require administration, conflicts with clause. What Mr. Justice David Richard said was that by reason of clause 7D and E, you can't prove, so you don't count as a provable debt, therefore you go back to NPQ.
And that was the point of disagreement, I think, between me and him, and then the Supreme Court and me.
Yes, exactly. Can I just finish? You also give me the answer, but right. If I go back to the Court of Appeal, 53, 1603. What your Lordship was considering, we looked at 38.
Which paragraph was it?
It's 39 on 1603. You say, well, 7D is neutral.
Yeah.
And then the question for 7E is, does it affect subordination? I.e., it only prohibits the lodging of proofs if the lodging of the proof would by itself impact on subordination. And what your Lordship said was, it doesn't impact on subordination, because if you do submit a proof, it's valued at nil. And therefore, the conclusion your Lordship came to, it's irrelevant whether you lodge a proof or not. So you don't get anything, and you do, it's valued at nil. Therefore, it's not a breach of clause 7E because it makes no impact on subordination. And that's the conclusion the Lordship came to at 62. There's 62 on page 1608. I conclude the subordination debt is repayable on contingencies that include payment of statutory interest and non-paid receivables. Valuation of contingent debt must take out of both contingencies. In that way, the lodging of proof will not adversely affect subordination. The lodging of proof point is irrelevant on your Lordship's judgment. And that was the point Lord Newey disagreed with. Going back to the Supreme Court, tab 58, page 1839.
Hang on, I need to get out another bubble.
Oh, sorry. That's right. Volume 4, 1839.
Yes, 1839.
1839, and just to we can start at 37. 37 is where His Lordship deals with the ranking issue. And that was the contractual issue, what does clause 51B mean, how it's applied in relation to statutory interest, non-provable debts, etc. And that was the primary argument about what the ranking question was. And that took His Lordship all the way down to 67, which concluded on the ranking issue, these were, if you like, ultra-subordinated, even below statutory interest. And that was a matter of construction of the agreement of clause 5. But he then went on, in a sense, almost by way of aside, but from 68, when can they lodge a proof. In a sense, it didn't matter at that stage. He already decided the ranking issues. But as it was still up for grabs, he then went on to decide the proof point. And his concern with your lordship's analysis was that even on a contingent basis, if you lodge a proof, it's not necessarily valued at nil. So you can't, if you like, get out of clause 7e by valuing it at nil, that might not be valued at nil, it might be valued at something else. And if you value it at something else, you are undermining subordination. And that's paragraph 68. And that's why he then reverted to Mr. Justice David Rich's analysis, which would be the logical conclusion if your lordship's assumption were wrong about the valuation, that 7e does interfere with subordination, and therefore by reason of 7e they couldn't lodge a proof. And that was how he dealt with that issue in that case. Now, he then went on to discuss the question at 70, or he raised the issue whether these were provable debts at all. And that issue, as I understand it, is a matter of great debate in insolvency circles that hasn't been resolved. But this, again, is not allowed. But that was a different question again. But the narrow proving of debt question turned on clause 7e between all the judges. And the particular disagreement between Lord Newberg and his lordship was whether if you submit a proof on a contingent debt basis, it's valued at nil or not. He wasn't even saying it's not a contingent debt, by the way. He was simply saying you don't value it. You don't necessarily value it at nil. And that was the source of disagreement. So, sorry for doing that. That's how we interpret those judgments. All of that, to be clear, is a long way away from anything lordships and ladyship have to deal with here, because for the reasons I explained, none of this arises from our case. So, and I move on eventually to ranking under the amended supplement. And just to say at the outset, we said there are two principal errors, and I think these are already from SLP 3 in the interpretation they gave to the lordship and ladyship yesterday in relation to the amended note. The first is that all the submissions are continually infused with the concept change. The persistent case before the judge was you start with the unamended notes, then ask whether there's intent to change. Now, my Lord Justice Lewison sort of pushed Mr. Phillips off that point by saying let's go straight to the amended notes, in which case the argument in a sense couldn't really begin. But throughout the submissions, he kept coming back to the point, kept on saying, well, this hasn't been altered, that hasn't been altered, therefore this makes a difference. All that is swept away in terms of analysis. One is not concerned with what's been altered or not. One is concerned with what the agreement actually says. So that's the first error. And the second error, as I flagged earlier, is although SLP 3 criticised the judge for his twin subordination analysis and say repeatedly, as Mr. Phillips said, they have to be construed as a whole, they don't really live up to that promise, because their approach is to derive the subordination outcome from the definitions. And then to say, well, the solvency condition can't change that. And the word used, their identity can't be changed. At page 54 on the transcript yesterday, what Mr. Phillips said, the conditionalities do not alter the legal characteristics of senior creditors, which we say, well, why not? Why do the conditionalities not assist in defining the characteristics of senior creditors? Mr. Phillips' approach, you set the list in aspect by looking at the definitions and then say, well, the conditionalities can't change that. That's not interpreting this clause as a whole. It's doing worse than the judge, but only interpreting the first half. And we say that's a fundamentally erroneous approach. It only looks at the definitions. But it also misunderstands, we submit, what purpose the definitions serve in the agreement. These agreements, when they refer to senior creditors and senior liabilities, they don't kind of list all senior creditors and all liabilities. It's not a matter of identity. They don't list them and say A to E are qualified, these ones aren't. Instead, the definition is merely a test, the application of which will determine who is and who isn't a senior creditor in any given situation. You don't change the definition. No one's changing the definition. It's the application of the definition. And the application of the definition is perfectly capable of being changed by the solvency condition. And we submit that in order to give effect to the solvency condition, one must at least be open to the possibility that that can change the application of the senior creditor population. But that's what SLB3 steadfastly refused to do. They cast the senior creditor's definition in stone as if it is a list, but it isn't. It's to be construed together. And that's why I said earlier, one starts with the statement of intent and looks at the mechanism. Now, the real question is, does that mechanism amount to an expression of seniority? If it does, you can then apply that to the text. And that's the real issue the court is asking. Now, on the judge's approach, he addressed the amended notes. He concluded that the provisions were, as he described it, unequivocal, and that they had a very clear meaning. He did describe the process that led to the amendments. That was just essentially by way of background, and I think no one's suggesting that makes a difference. And we submit that his judgment on construction was clear and very correct. If one goes to the amended note now, that's Core Bundle 3 at 42. As we know, it's clause 3. What the notes achieved after setting out the initial statement of intent of subordination is to provide a mechanism of subordination in two scenarios. The first scenario is outside of winding up, and in that scenario, the payment in the notes is subject to a solvency condition. We'll come back onto that in due course. In the second scenario, inside of winding up, the solvency test is disapplied and is replaced by a regime which ranks the subnotes at the level of notional preference shares with certain specific characteristics which we'll look at. Those characteristics closely define the ranking of the subnotes, and specifically we say place the subnotes below all other debt other than any debt of notional holders of which there are none. And we submit that was the judge's approach, and we submit he was plainly right for the following reasons. First, the creation of the two scenarios is what the words actually say. What the words say is there's a conditionality by reference to insolvency, and then the conditionality shall not apply where there's a winding up, and therefore a different scenario. So there's a test outside a formal insolvency, and a test inside a formal insolvency. And the two regimes are necessarily mutually exclusive. That is what the words say. Second, it's plain, we submit, that both scenarios are concerned with and address the ranking of the subnotes. The subject matter of clause 3 is status and subordination. That's what the clause is about. The wording introduces the operative, the word accordingly, as we submitted earlier, it introduces the operative provisions which implement the subordination. And they use the very techniques described by Fuller in his passage that we looked at. The two techniques he refers to, the two techniques they use in different regimes, solvency condition and preference share valuation. The very things that he describes are being used to subordinate. Third, this specific drafting technique of ranking debt at a preference share level was used by Lehman in other instruments, which were before the court, and I think before this court.
How does that help to construe this instrument?
Well, only to say this, my lord, that technique has been recognized by all these parties as effective for that purpose. So it was common ground on the other instruments using the same technique or similar technique that it achieved subordination by reference to the preference share concept. So,
Well, to borrow a phrase from the judge, so what?
well, okay, but I won't push that one. Fourth, no, third. The use of the technique we submit carefully calibrates the ranking position by reference to the type of instrument concerned, and thereby it inherently creates, by reference to my lady's point yesterday, both a floor and a ceiling for ranking purposes. Because we know whenever there's a distribution and a winding up, there is a waterfall, and that waterfall reflects, absent contractual differences, the type of instruments involved. And we know, by the reference to the waterfall, that creditors and shareholders stand in different positions in the waterfall. And it's very clear that shareholder level, and including preference shareholder level, is below debt level. One knows that from waterfall. The preference share fits into the waterfall above ordinary shares, but below debt. And therefore, inherently, my lord, this provides a ceiling and a floor because it ranks notionally the recovery on this subject equivalent to a preference share with those characteristics. And by doing so, it necessarily places a brick in the wall with a mixing my metaphors, I'm afraid, a ceiling and a floor, because that is inherently a characteristic of a preference share. So far as relevant, but there were some points floating around, we don't say that it turns the debt into preference shares, it clearly doesn't. It's a deeming provision for the purpose of ranking. We don't say that deemed ranking is the same as ordinary preference shares, because it's not. It says that. We do say that it necessarily deems the subnotes below all other possible forms of debt, other than notional holders. But of course there aren't any notional holders, so it's a bit of a red herring with notional holders. We do say it clearly and explicitly deems the subnotes necessarily to rank below all forms of debt, other than notional holders.
And does the assumption that the notional preference shareholder is entitled to 100% return on principal and interest necessarily rank the notional preference shareholder above real preference shareholders?
No, the 100%, my interpretation of 100% is they needed to put 100% in because these were ultimately debts. So they weren't preference shares, they were debts. And therefore it needed to ensure that even though the ranking is at preference share level, they were still talking about the value of the debt. So the amount to be proved would be 100%.
No, I follow that, but if they were to rank equally with, as it were, real preference shareholders, they might have to share pari passu with whatever's left after everything else has been paid.
Yes.
But the deeming provision, one might think, says, well, no, they haven't got to muck in with all the real preference shareholders. They're above them because they're nationally entitled to 100% return.
Yes, the deeming provision makes it clear that there's a layer of preference shareholding for ranking purposes. There's like an ordinary common or garden preference shareholding, and they fit in the normal place. So what they call notional holders, there are only, they fit in just above them, and there are these things which they fit in just above them. So they're never competing with the real preference shareholders. They're only competing, well, not competing with anyone, in fact. They're competing only when there's money left available after all the debts have been paid.
And it's just a means of placement.
It's a means of placement. But importantly, it's not a means of placing a floor. It must be a means of placing a floor and a ceiling, because the concept of a preference share does that. Because the waterfall tells you it does that. And that was the critical point we submit from the judge's point of view, that you can't have a halfway house, you can't have a one-way ranking. The concept is both ways. And there's no difficulty in the ranking of the preference shares versus the notional versus these things. Equally, there's no difficulty with these things versus other subordinated debt. Because they all have a place. There's an infinite number of ranks you could have. And these notes place very precisely the ranking position of these instruments.
And the whole purpose of the deeming, I mean, to state the obvious, is to provide an answer to the ranking question.
Yes.
Right? I mean, I say that because there's a lot of authorities, I'm sure you're aware, on the construction of deeming provisions in statutory contexts. And the sort of general test which emerges is you only press the deeming as far as on an interpretation of the statute as a whole it's intended to go, which is perhaps a statement of the obvious. But here, on any view, the deeming to which you contend is absolutely central. So, I mean, its purpose, I'm sorry, is absolutely centrally to achieve a ranking outcome.
Yes, absolutely. The only thing it can do.
It's the only thing it can do, and it's the only reason for having it in the first place.
Yes.
So there's no possible argument that this is somehow outside the scope of deeming or anything of that nature.
No, because
At least I find it hard to see how that argument would run.
as Lordship and Ladyship may be aware, and I think it's a point we come on to later, at other times, Lehman did convert debt into preference shares. He did take the step of saying these are now preference shares, and that would affect the consequential impact of the same ranking too. But these weren't converted into preference shares, but they simply, and could only, as you say, rank them as preference shares. And that's, we say, the plain and obvious purpose of the objective purpose of the words used.
Does that produce, or at least potentially produce, a different ranking according to whether you apply the solvency test or the insolvency test? That was one of the points Mr. Phillips made yesterday, and he said that would be a quite irrational outcome.
Yes. Well, let me. I was going to come to that. Let me just take that out of.
Well, no, you come to it in your
I
own
will
time.
come to that.
Yeah, fine.
Because there are a number of points in response to it. I was going to come back to those particular points that he raised.
Yes.
And what one then does when one appreciates, we submit, what this clause does, is one then plugs that into the agreement. Because we submit that a ranking at preference share level, if it means what I submit it does mean, it amounts to an expression of juniority over other subordinated debt. Because that is the consequence of that leaving provision. Leaving out notional holders, because they weren't any anyway. What that clause does is say these notes are subordinated to other subordinated debt. Therefore, one goes back to the instruments, one plugs, and when I said earlier, interpretation hasn't changed, the application may change. One goes back to the sub-debt agreement. Was this an excluded liability? Is an excluded liability if it contains an expression of juniority? We submit the solvency condition and the sub-notes were an expression of juniority for the purpose of the sub-debt, and therefore they were an excluded liability for the purpose of the sub-debt. And that is the key critical difference. That cracks this nut. Because we know, in the judge found, there's no challenge to it, the sub-debt agreements contain no expression of juniority. As a result of that, if you go back to the sub-notes, the sub-debt agreements were senior creditors, because they had no expression of juniority in their insolvency condition. And therefore you have a perfect mismatch. Perfect match. You have this let's call it claim B, the sub-notes were excluded liabilities for the purpose of sub-debt, because they contain an expression of juniority. The sub-debt were senior creditors in the sub-notes, because they contained no expression of juniority. And that's why I said earlier, one meshes the definitions together and applies them. Now, what do SLP say about all this? And leaving aside the intent to change point, which I mentioned, the primary argument seems to be, as I said earlier, that you get all you need from the definition of senior creditors. But we submit that actually begs the question, because you can't apply that definition without asking the question, does this solvency condition amount to an expression of juniority? They're asking the wrong question, and therefore coming to the wrong answer. But beyond that, they make various attacks on the conditionality itself, and I have to deal with those clearly as to what it means. The first point, and I think this came up through a number of the arguments, is that the preference share wording sets just a floor and not a ceiling, by use of the word over in particular. But we submit that's simply an impossible construction of what this agreement does. First, it doesn't reflect the words used. The words simply don't say you're entitled to a return over X, Y, Z. They say entitled to a right of payment as if the holder of a class of preference shares. And that's a critical bit of ranking we submit. Secondly, as I said earlier, preference shares are clear and recognized place in the insolvency order. There's no doubt about where it fits. Third, we submit it would be written down here commercially absurd, but I suspect that's going to be too high. Let me just say strange to have a one-way ranking provision, which is no offense case thing. You simply set out all these provisions about preference shares for the purpose of defining the floor with no statement of the ceiling. We would submit that to be a strange outcome of interpretation. No reason is given why someone would want to do that. And it's not enough to say the definition does that for you, because then runs the problem about not applying the definition doesn't make sense. But fourth, moving on from that, on SLP's argument that this is all about the floor, the entire drafting exercise would have served no purpose. Because absent all this wording, of course the debt ranks ahead of preference shares. So if they're saying, well, this is just to clarify that it ranks ahead of preference shares, it's absolutely meaningless. There would have been no purpose at all to do that. Maybe it helps, I don't know the rectification, but there would be no purpose at all in setting a floor which is already set. The only objective purpose of this, consistent with the concept of preference share, is floor and ceiling. Even more strange, fifth point, when the alternative regime, and I'll come on to that regime in a minute, does have a floor and ceiling through the solvency condition. It would be very strange, even more strange if you like, to have two regimes, one with a floor and a ceiling and one with just a floor. There is no, we submit, logic or purpose in that submission, which places far too much weight over the word over. It doesn't actually reflect what the clause actually says. Now, the second argument, and I think this now I can give my Lord's point, I'll try to, is the suggestion that it then produces different regimes inside and outside of winding up. The first answer is, paraphrase, so what if that's what the clause actually says? Because as I say, there are two regimes set out in the clause. But I think I say a bit more than that, because it's not in any way unusual, we submit, to have different tests for ranking in and out of a formal insolvency. Even if one goes back to the sub-debt agreement, for bundle 3 tab 38. Page 678. Clause 5.1. That's two regimes. Different tests. So under 678, under 5.1a, there's a particular test in an insolvency by reference to, 6.8 outside an insolvency by reference to financial resources requirements, which are reference to the regulatory regime, and B, a solvency test, it's applied for all of them. So even on the face of the subject, it's at least potential for there is at least potential for there to be different ranking outcomes in and out of an insolvency, when on the face of it, there's a different test which has to be applied in and out of an insolvency. But even more than that, subordination provisions are often triggered only in a formal insolvency, which necessarily means that, at least in concept, the ranking can change by reason of an insolvency. If you go to, one goes back to Authorities Bundle 1, That's page 304, which is Maxwell.
344.
304.
304. We're back into Maxwell.
Back into Maxwell. And just an obvious point, that the subordination provision at the bottom of 304 in Maxwell was triggered on insolvency. So, last line continues an unsecured and subordinated obligation in that in any case of any distribution of assets by the guarantor, in liquidation or bankruptcy of the guarantor, etc., and then there's the payment out conclusion. Very often these subordination provisions only take effect in insolvency. The consequence being that notionally at least ranking changes in insolvency, because pre-insolvency they hadn't triggered. So there's no difficulty in concept in having a different regime before and after insolvency. Indeed, that's inherent in some of these clauses, which are only operative on insolvency. And nor we submit is it surprising or relevant, because it's only really a formal insolvency that ranking matters. Outside insolvency, if you've got the money to pay, the ranking issue is maybe of academic interest, but there's not really practical interest if you can pay all your creditors.
Well, I put that to Mr. Phillips. He disagreed. He said that where you are in the ranking in the event of insolvency greatly affects, effectively, the market value of whatever it is that you've got.
Well, what I think he was saying by that is that the fact that it's an insolvency trigger may affect your perception of the instrument before insolvency. But what he's not saying, I didn't think he was saying, is that the ranking issue otherwise has any relevance before insolvency, because the ranking issues, it doesn't matter. I mean, it's only relevant insofar as insolvency is an outcome. But before insolvency, we submit the fact that there are two regimes isn't a difficulty. Equally, if one could also say, and it's also right, that it's the insolvency trigger that is relevant for regulatory purposes. If you go, please, to Authorities Bundle 2, tab 36. Authorities Bundle 2, tab 36, 891, decision of Mr. Justice Blair, helping. This was a subordination. This was a subordination issue in a regulated context. So it had a slightly more relevance, I suppose, as far as any of this is relevant. If you go to paragraph 5, you can see the solvency, the subordination provision in that instrument, and the bits underlined again indicate that the subordination provision is triggered in the event of a winding up. So once again, no subordination pre-winding up, but subordination in winding up. So you have again inherently two regimes. The reason why one sees these regimes, or appears the reason one sees these regimes, is if you then move to paragraph 11. The judge, paragraph 11, explains that it is because the subordination provisions are effective in an insolvency that subordinated debt can qualify for inclusion in the capital issuing bank for regulatory purposes. So that's what matters. And the reason, or at least the support for that, is that paragraph 12 is a reference to the EC directive following the Basel 1, and you can see the quote there. The requirement for subordinated capital is that binding agreements exist under which, in the event of a bankruptcy or liquidation, there's subordination. So there's no point here that you can have different regimes before and after insolvency. the face of it, lots of subordination provisions do have different ranking regimes before and after insolvency. And for regulatory purposes, what matters is that you've got a post-insolvency subordination regime. So we do submit that one goes to the words of clause 3 and the consequence that that might give rise to different regimes is not a consequence that displaces the words. As it happens, we also submit, and I'll come on to this on the unamended point, that certainly in this case there's no actual difference, because of course we say on the solvency condition the same conclusion obtained. So I'm not saying in a different scenario, on different facts, you might have a different conclusion. On the facts of this case, we submit, and I've got to argue this, that under the solvency condition, i.e. pre-winding up under the amended notes, or in all cases under the unamended notes, claim B still subordinates to claim A. There's no actual difference.
Well, that may or may not be so, but if we're looking at the interpretation of the instrument, we can't confine it to a particular set of facts.
Lord, I accept that. Well, it has to be considered in the round. That's why we submit in the round. So what? Now, the third submission by SLP3 against my interpretation is that it leads, it was said, to some inconsistency with the definition of senior creditors in the subnote, because the definition of senior creditors in the subnote contemplates that the subnote might be senior to other subordinated debt. You should recognise the point. There's a potential for layering of debt in the subnotes. And they said, well, hang on a minute, if you're subordinating to the bottom of the queue, it's inconsistent with the contemplation that these subnotes might be higher than something else.
Well, it might be higher, might be lower.
Might be higher, might be lower. And we've got the notional holders. On the face of clause 3, there is a theoretical, at least, subordinated debt above which the subnotes will sit. So there's no inconsistency in the definition of subordinated creditors. To me, there's contemplation that there could be layering. And if there's a contemplation that could be layering above, that's catered for too. I would submit that that sort of argument wouldn't matter because it's so remote. But I've got a sort of neat answer to it that's actually catered for as it happens to the notional holder issue. More generally, we do submit that, and the argument comes in once or twice, when construing these instruments, we submit it's not helpful or not immensely helpful to speculate about what some other instrument might or might not say that might or might not be inconsistent with what this instrument says. And the example that has been given against me is, well, how can the subnotes subordinate to the preference share level? What would happen if another subordinated debt had a contract that said, we are subordinated to the subnotes? You'd have another contract that expressly contradicted what I say this agreement says. We submit that isn't particularly helpful. It's not really a matter of interpretation. One interprets the agreement that goes to application. Theoretically, it's possible, it didn't happen, but it's possible, I suppose, because of this cross-referral technique, another instrument cross-refer in an inconsistent way. It doesn't, we submit, changes the interpretation of what the agreement says, but it's possible that in some world or another, somebody might put a spanner in the works. Now, if that were to happen, we would submit, it's a matter of application. How do you then apply these together through that cross-referral technique? And you might end up somewhere where the judges end up saying, well, it doesn't work, and therefore you revert to parrying something. There might be an outcome outside the contract. But it's not helpful, we submit, in construing what the words say, to say, well, something else might come into play, which might make that a difficult application. Because that's a different question. It's about application of an inconsistent contract, as opposed to the proper interpretation of this contract. So we submit that isn't especially helpful. Now, the fourth submission was that somehow the explanatory note helps your lordship in the construction. The judge was right in his treatment of this note we submit. He saw it equivalent to a recital. we said it was something of that order, it's not an operative term, it doesn't give performance obligations, but some indication of intent, I suppose, and that's why it's something similar to recycle. But it doesn't have to wait. It's not irrelevant, but it doesn't have to wait to change the interpretation of the actual words used. It's certainly wrong to approach the exercise I submitted to you yesterday by starting with the recital and then proceeding on the basis that must be right, therefore everything else has to bend to its construction. That can't be the right approach. In any event, we submit the recital isn't inconsistent with our submission, and if anything, it's consistent with it. Do you need to turn it up, or do you have it?
Page 7 for 1.
Page 741.
741, yeah.
So it confirms that the amendments are concerned with ranking, 101. It confirms that the effect of ranking are winding up, 2. It's intended to ensure that the notes rank above any upper tier 2. The expectation we submit in the face of the contract is that the upper tier 2 be the notional holders. The upper tier 2 notional holders could be put as a preference share level. And it's a reasonable inference we submit that had the draftsman intended to provide a deemed preference share was to rank pari passu with a debt, he'd have said so. I know, of course, that's not the best approach to interpretation, but I say that with a bit of a tin hat. But we do submit one doesn't get anything out of this. It says no more than the actual words say themselves in the operative terms.
Well, the tier 1 capital would be shareholders.
Tier 1 would be shareholders.
But what about upper tier 2?
Upper tier 2 can be shareholders or undated subordinated debt. And what we submit, reading the clauses together, and I can't for the moment revert to the verification evidence, but reading the two together, the expectation is that the upper tier 2 shareholders would be the notional holders. So the notional holders are debt who are ranked at a preference share level. So we submit that when we read those two clauses together, they fit absolutely precisely. The wording of the operative terms confirms that even though they're ranked at preference share level, they are nevertheless ranked above notional holders. And notional holders are debt holders ranked at a lower level of preference share. And we submit, reading it together, certainly there's no relevant inconsistency, that when he refers to upper tier 2 holders as being below this instrument, what is being contemplated in this explanatory note, insofar as can bring any meaning out of it, is upper tier 2 shareholders could become notional holders. There's no other category of debt referred to in the instrument. So we submit it's entirely consistent, but we're a long way away from the suggestion it's so inconsistent that this document is interesting. And the fifth submission, I think we dealt with this briefly, was the point of the 100%, as how that interfered with the analysis. I think that's a throwback to the point which has been made. It's not a real preference share. Of course it's not a real preference share, but it's a notional preference share. As part of the drafting process, it was clearly thought necessary to ensure that because it was still a debt, there was a value to be put in the debt, which could be proved. So it would be proved for the value of the debt, but ranked a preference share. And that's all that. The last point on this, by reference to Malcolm's skeleton, which I shall deal with briefly at paragraphs 882 and onwards, he makes some points about factual matrix in the interpretation of this instrument. The reasons we submitted earlier, the factual matrix being the supposed purpose within Lehman of the amendment, and we submit the reasons you wish that isn't relevant. In fact, there's a lot that could be said about the purpose of these instruments. If one actually has to get in there, the purpose will be the purpose objectively apparent in the face of the agreement. And the purpose of this agreement we submit in relation to clause 3 was to deal with status and subordination, which is the meaning of the term. So, I'm not sure how that's factual matrix anyway, but we
Yeah.
So that's where we get to on the amended note. We submit the interpretation given by the judge is right, and I've sort of explained how that's consistent with the two clauses. Can I now move back in time to the unamended notes? But first, in order to do so, to identify the potential relevance of that, you may have picked up from the judgment there was a bit of a debate as to whether it's necessary to go into any of that at all. I think the lordship's question, the one raised by the judge, is why am I dealing with something from history? But I suppose it's relevant to the rectification case, so we have to deal with it.
Well, I see that. I mean, if there was in fact no change in ranking between the unamended notes and the amended notes, then there's no relevant mistake.
So we have to deal with that purpose. And so the judge concluded in his judgment on this issue, the unamended note, that claim B ranked ahead of claim A. Both parties agree he was wrong about that, although we disagree as to how far he was wrong. Mr. Phillips says it ought to have been parry, and we say he ought to have held claim A as priority over claim B. We can go briefly with the judge's error. He sought to apply the cross-referencing provisions in the two sets of definitions, but we submit misapplied them on his own reasoning, and there was in a sense, a rather clear error. One can see it in the reasoning. Set out in our skeleton 32 to 36. I don't want to spend a long time on it because it's the more important thing to do with. But if you go to the judgment, please, CD 222, page 401. That is the page before it says table. But the table sets out the process of reasoning. And of course, the process of reasoning involves the cross-referring to the other instruments that we're now familiar with.
The table starts on page 400.
It starts on page 400, paragraph 95. But if you go to page 401, it's his letter 4D, where he sets out the sort of meat of it. So he says, we can read it, but if I can indicate where the problem arises. He's in the subnotes at the moment. He says senior creditors are defined as subordinated creditors other than those whose claims rank or express the rank pari passu. In other words, excluded from the definition of senior creditors are those whose claims rank or express the rank pari passu. You exclude that. This in turn requires reference back to the provisions in the subject, which is fine. It says PLC's claims do not fall within this definition. We agree with that. They are, on their own terms, subordinated and are not expressed to rank either pari passu or junior to SRP3's rights. So far,
Therefore, you say they are not within the exclusion.
yes, exactly.
Therefore, they are senior creditors.
Yes, exactly. That's the mistake.
Yeah.
So on the judge's approach, the subdebt ought to have been senior creditors in the subnotes. The subnotes ought to have been senior liabilities in the subdebt. You have the impasse on the judge's approach. How you then solve that impasse is not part of my submission because we submit there is no impasse. I can quite see pari passu might be the answer one way or the other, but that's not the matter of our case. We say there's no such impasse. But assuming there was that error, it's at least pari. However, the critical distinction which the judge didn't apply when he undertook this case was the material difference in the solvency conditions between the two sets of instruments, the subdebt and the unamended subnote. If we can go back into the subdebt, that's full bundle 3 tab 38. Page 679 has the solvency test at clause 5.2. And the solvency test, there's a single solvency test. I don't work out whether you call it a cash flow or balance sheet. It's a bit of a mix of the two, but it's a solvency test by reference to the concepts within the definition. So by reference to, as we see, liabilities, subordinated liabilities, etc. So it's a single solvency test which plugs in the definitional terms. And make the obvious point, in so doing, makes no overt, contains no expression of juniority over anything else, because it simply applies the definitions, and those are definitions the judge has already found there's no expression of juniority in any of this. If one then goes to the unamended subnotes, which are tab 41, there is a solvency test on page 723 in materially different forms. Specifically, there are two distinct solvency tests in clause 3D. A cash flow test and something like a balance sheet test, if those are the right terms to use. By clause 3A, the solvency condition must be satisfied before any payment can be made. The two limbs are joined by and the judge held, and it's not disputed, that these are cumulative, i.e. both must be satisfied. There's no challenge to that finding. Judgment 171, subparagraph 2. Now, under the first one, which is the one we wish to focus on, the cash flow condition, the precondition of payment, and remembering going back to Fuller, this is how you achieve subordination, by calibrating where you set the solvency test. The precondition of payment is it must be able to pay, quote, its debts as they fall due. Now, we submit two elements to consider in those words, however one applies them. First, the meaning of its debts. That wasn't expressly considered by the judge in his judgment, but we submit it could only really have one meaning. I'll come back to the submission against me for a minute, but we say it must mean all of its obligations to all other creditors, i.e., its debts means all of its debts, and therefore including its other subordinated debts. There's no route, we submit, as a matter of interpretation or reason, to place a limitation on the words used. For example, to mean its unsubordinated debts. That's not what the words say.
And you're using the word debts, are you, in the insolvency sense? So include, for instance, claims sounding in damages, which are within the insolvency concept of debts, but wouldn't normally be thought of as debts at common law.
Well, I don't think I need to go that far. I'm only concerned with debts in terms of genuine common law debts, but I see no reason why it wouldn't have that wider connotation. That we submit that is, in a sense, easy to do. We submit that there can only be one answer to that. The second question, which the judge did deal with, is whether, or is the question of when you apply this test, i.e., is it whenever another debt actually becomes due, so that if it's not satisfied on that date, it can never be satisfied as a one-off trigger, or is it to be applied whenever a payment comes to be made? You ask, can you now pay your debts as they are currently due? As a sort of running test, by reference to all debts due and unpaid. The judge concluded it wasn't a one-off trigger, but it had to be tested from time to time when a payment comes to be made. And we submit, I think both would suffice for my purposes, but we submit he was plainly right in so doing, that it comes to be applied whenever a payment under the notes falls to be made. The question is, can they now pay all these debts presently due? That's what we say that those terms mean. The problem from the judge's analysis and his judgment is that having reached that point in the analysis about debts presently due, he kind of ignored this bit of it. He didn't give effect to this solvency condition. He then jumped to the second solvency condition and started talking about that. He didn't you've seen that, I won't go back to it, the judgment deal with the effect of this cash flow condition. And what we submit,
Just give us a couple of paragraph references. You don't need to take us to them, but where in the judgment does he deal with this?
well, if you go, it's 171, if you go to page 396. What you, this paragraph, this is 171, he's dealing with the solvency condition in the subnote. And at 1713, which is on page 396, this is where he deals with the its debts point.
Yeah.
So this is where he concludes the time to time. You see 1713D, that's the conclusion time to time. He then says, turning to the second limb of the solvency test,
Yeah.
and he says something like that. But then, I mean, we don't get any more. What he doesn't do, he doesn't plug that into the analysis. And we submit, taking the same technique advanced in relation to the amended notes, is that the solvency condition, when properly interpreted, is a further expression of juniority in the subnotes. Because it's necessarily an expression of juniority for all other debts as and when they fall due. And therefore, again, same process, one goes back to the subdebt. There is an expression of juniority. Therefore, the subnotes are an excluded liability. Conversely, the subdebts are a senior liability. So the key in both these analyses is to identify the solvency condition as amounting to an expression of juniority over other subdebts. We submit a cash flow condition in these terms, in these broad terms, is an expression of juniority over all other debt, including other subdebts. And deal with the submissions against that position. Apologies, I haven't got all which we don't. The first submission is a general point which comes across all these submissions, is that the whole thing is answered by the definition of senior creditors. But as I submitted earlier, that's only half the exercise. One has to see the solvency condition affects that definition. The second submission, more particularly on this point, is that its debts doesn't mean its debts, but only its debts owed to senior creditors. So it's a submission on interpretation that one qualifies those words for the purpose of the cash flow test. We submit that would be an erroneous exercise, interpretation of the words. First, it's not what the words say. They don't say its debts owed to senior creditors. Secondly, all the more so when the clause draws a distinction, we submit an overt distinction in the two tests between its debt, little d, in Roman 1, and Roman 2, which refer back to the definitions. Roman 2 refers to assets, refers to liabilities, and refers to senior creditors. There's an overt contradistinction in the two clauses between the two concepts being involved, being used. And we submit that where the clause specifically uses different language to deal with different concepts, it would be wrong to construe them as if they mean the same thing. Because that is SLP3's argument. The third point advanced, I think this is advanced, is that it might be suggested that if you go back to the clause, the bit in parenthesis at the end should qualify both tests. I can say no more than it is a matter of interpretation. We submit that would be a very curious interpretation of this clause. When the bit in parenthesis expressly uses the words capital L liabilities and capital S senior creditors, and we submit qualifying the words capital L liabilities as opposed to something of a different nature in Roman 1. I can't say as a matter of language it couldn't be possible to read that parenthesis as qualifying both, because I think the punctuation permits it. But I would submit as a matter of ordinary interpretation it would be the wrong approach, and that the right approach is to read that qualification as applying to the capital L liabilities, which it's actually talking about. And the fourth point is a point that I think I've already covered, which is that this, or it's actually equivalent to that covered, which is that, actually that's an entirely different point, I'm sure, is that if you have these two tests, they're different, and therefore they might result in different outcomes, because you might have a cash flow problem or a balance sheet problem, and they might produce different outcomes, therefore might have a different conclusion of ranking. In a sense, if they result in the same thing, there'd be no point having them. They have built in, and we say correctly, cumulatively. Necessarily, they are referring to different things. And the process of subordination ensures, we submit, that the right approach to this is that the consequence is these notes are very, very, very far subordinated.
But I mean, even in an ordinary insolvency situation, you might be cash flow insolvent, but your assets exceed your liability. Conversely, your liabilities may not exceed your assets, but you can pay your debts as they fall due. Either way, you're insolvent.
Either way, you're insolvent. Exactly. Two tests means there could be two different ways of getting there. Equally here, two tests means there could be two different ways of ensuring subordination. The end result is to ensure as much subordination as they could. Well, that's the effective result of this. By having two different tests, both must be satisfied. Therefore, there's a greater chance that these notes come to the end of the queue. So there's no difficulty in having different tests. Indeed, that is the essence of the clause. And the last point on, I think, this construction issue is a similar point, which is that, well, how would this work if another instrument subordinates itself to this? Again, you've got the same problem. You've got a potential conflict down the line with a hypothetical instrument. It could, in theory, exist. It doesn't, but it could. But that would be a problem of application, not interpretation. For the same reason I said before. So the rogue instrument which interferes with this isn't, in my submission, a reason to change the interpretation of the case. So that is what I understood to be the response to that. Can I now deal with the additional points made in my learned friend's skeleton? I'm not sure I've fully done, or I ought to cover them, on the unamended notes ranking issue. And can I ask you to turn up the skeleton at CD1, tab 7, page 71. And from paragraph 45 onwards, there is what I understand to be SLP's positive case on the construction of these instruments. And we said the judge got it wrong, which we're in agreement about. There's then the positive case they advance, why parapassive ought to be the answer. And just in passing, they don't deal with a solvency condition in this analysis. So it's a bit of a side wind. We say they miss the point, if you like, but they're all right. Let's deal with what they have said. There are two aspects to it. The first aspect, if you look at 47, is the pari passu preference, which I've already dealt with. As a matter of approach, that's the wrong approach. The second aspect, slightly more intricate, begins from 48, which I'm not sure if I've read it, so it should be immediately. It essentially involves framing the question, a rather different question, as to whether the subject and the subnotes are subordinated to the, quote, same senior creditors. And this featured very much the argument before the judge. And having framed that question, they give the answer. In fact, you can see the answer at 45, the last sentence. They are subordinated to the same senior creditors, such that they are not subordinated to each other. The argument was, well, you can ask, are they subordinated to the same set? And if they are, that gives you the answer. There are various references to the clauses being symmetrical and looking at the same sort of thing, and therefore having the same set of creditors. We've always submitted that's a very unhelpful approach to the court below and the lordship. Essentially, it's seeking a shortcut which doesn't really work through a bit of ambiguity in the language. And as we said in our skeleton, produce an answer which is either irrelevant or unfounded. Because one has to qualify what one means by same. The question is, do they have common senior creditors? The answer is yes. All the unsubordinated creditors are common senior creditors. So to that extent, yes, fine, but that doesn't help us in ranking inter se. If the answer is, well, do they have exactly the same senior creditors? The answer is, well, we look at the contract, see what it says. You can't get the answer by saying, well, we've got the same senior creditors. And that's the problem with the analysis. Those are back to the skeleton if you want.
39,000 people didn't win the London Marathon. It doesn't mean they all came second.
Yeah. Well, we have sought to pick up the problem, already ahead of me, but at paragraph 11 of that skeleton. Paragraph 21 of the skeleton, page 62.
Your skeleton.
No offense, skeleton.
Sorry, where are we going? 21. Paragraph 21.
Page 62, paragraph 21.
Yeah.
And it's the syllogism of paragraph, and this is the essence of the case. So it says, the two subordinated debts to rank pari by operation of law are not necessarily cross-refer to each other. It is efficient that they are subordinated to the same senior liabilities, that A subordinates its debt to C and B subordinates its debt to C. A and B will prove at the same time and will rank pari. You also see the gap in that. That assumes that they rank at the same level. So it assumes classically what it seeks to prove. So all the stuff you see in motor and skeleton, that's symmetry and same creditors and all this, so it doesn't answer the question we have to deal with, which is ranking. Well, that's all I wish to say about the unamended notes. I can flag but not deal with the residual point, just to mention it, as you will probably recollect from the judgment. The judge also considered separately a ranking issue as between what he called claims A1, 2, and 3. That created a lot of problems in its application because potentially it impacted on the solvency condition, which was resolved eventually by the judge. And the problem, of course, in those instruments is they do say the same thing. No. So then that can't be cracked. And the question is, how do you find an answer? And he found the answer that as a matter of law, they revert to pari. We suggested, no one disputes the answer, we suggested it may be possible to find an implied term to deal with that, but it doesn't really make any sense. It doesn't impact on any things we have to concern ourselves. The knock-on point was if they do revert to pari but aren't otherwise excluded liabilities, how does that impact on the solvency condition? The judge dealt with that, I would say, as a matter of law, it doesn't. We don't disagree with that. We think there may be a better answer through an implied term, but it's in our skeleton. I don't think I need to trouble your lordship with it, because no one's arguing that what he decided was a wrong conclusion. But what he decided wasn't relevant to the issue I'm arguing. So I thought I'd mention it, but no. So that takes me in good time on to the question of rectification.
And for the purpose of this part of your argument, we assume that you're wrong in your interpretation of the unamended notes, and that either they ranked pari passu or alternatively B outranked A.
Yes.
Doesn't really matter which for this purpose, does it?
They were changed.
Yeah.
The claim advanced that the lordship and leadership are aware of the trial was rectification on the ground of mutual mistake for over 30 lines of the amended notes, essentially the whole of the new clause 3A, subject to small little bits. Frankly, we do submit that this case was misconceived at trial. No prospect. I've got 4 points to run at. any one of which kicks this out. Actually, all of them, but the points are this. First of all, there was no evidence at all about the intention of the actual decision makers. That's my respondent's notice point, but it logically comes first, and it frames the other question, so I shall have to deal with that first, if you will forgive me. So no evidence about the intention of the actual decision maker. Second, there was no mistaken intention on the part of Miss Dolby or Miss McMorrow, who were alleged to be the decision makers. Third, no objective manifestation of a call. And fourth, quite what my Lord Justice Lewison began with yesterday, the case is structurally impossible and collapses under its own weight, because what they seek to rectify can't, on any view of the facts, be available for rectification. Because it's plainly wrong. And that was a point which had been raised by the judge. And then as he said, what your case is a narrower bit of rectification is what you're actually after. But no such case was ever advanced. It always went to the jackpot, which was everything. And it's simply can't work. I'll come on to that. So if I can briefly recap on the factual material so far as I think relevant, just to put it in context. Actually, lordship and lordship. Subnotes issued in 2007. By 2008, it was perceived that there might be a US tax benefit by deferring the payment of interest until later. The process was started on the 2nd of June 2008. And if you can turn, please, to Supplemental Bundle 2, page 416. So just to your lordship, they should be aware that personnel, Ms. Dolby worked in the European Tax Department of Lehman UK, and she's emailing at the middle of the page. Miss McMorrow is an in-house lawyer at Lehman UK. Miss Dolby gave evidence, Miss McMorrow didn't give evidence. The instructions went to A&O and were signed to Mr. Grant, who did give evidence. Moving on to 417, as you have seen, on the 5th of June, Mr. Grant sent what we referred to as draft 1 and said, in the terms of the email, that he was going to have them blessed by Amrit, that's the 4th paragraph, who was the tax associate at A&O. So far as draft 1 is concerned, if you move these to page 421, which is that draft, there was no change to clause 3 on page 421, which remained unaffected. There was a change to clause 4F on page 422, which permitted the deferral of interest. So the original instructions and intent were achieved in draft 1 by clause 4F. And that was, as far as that bit of it was concerned, that wasn't, there were some little consequential amendments as well, but that was never changed. That was done in draft 1 by the 5th of June. At or around that time, Mr. Grant and the evidence spoke to Mr. Dehaun to identify a different, Mr. Bill was right, there were two, a different tax-related issue around the solvency condition at clause 3, and he proposed that the solvency condition be removed on a winding up. If you, I think it may be best to have both supplemental bundles out rather than anything else at the moment. Let's carry on, see how we get on. That suggestion from Mr. Dehal led to an internal drafting exercise by Mr. Grant. And still in this bundle, if you go to 433, on the 11th of June, this is an email he sent. I think Ms. Thomason was a trainee, as I remember. This was an internal email of his then current thought process. And what he has done in this intermediate draft is, if you then go on to page 437, he has made an amendment. This didn't get to Lehman, this is an internal version. 3A, amendment to 3A, which simply removed the solvency condition and winding up. So that, in a sense, dealt with Mr. Dehal's concern that the existence of the solvency condition might create a tax problem. The immediate response was to remove it. Just note on that, this on its face was an overt change to the subordination provision, responsive to the tax concern, and by doing so, that created a two-stream process, like in and out of insolvency. This change was not directly related to the deferral of interest, because the problem arose on the original notes. Anyway, when I say the problem, there's been no finding there was no problem. And it was never even argued there was no problem. The problem arose on the original notes. What Mr. Grant said, this is where we have to go to bundle 1, I'm afraid.
Supplementary 1.
Supplementary 1, tab 1, page 15. Page 15, paragraph 35. He said that, second line, the concern about tax deductibility did not relate to the new provisions. The potential issue had also arisen in the original notes, although the proposed interest deferral could potentially have exacerbated the problem. So his evidence, in which he wasn't challenged, was that there was a link between the tax concern and the interest deferral proposal. That issue wasn't explored any further. That's what his evidence. But anyway, we saw the intermediate draft, so it removed the the insolvency condition. That then led to a further concern within A&O. By that stage, the draft had been circulated to Mr. Grant's superior and Lord Moselle, the partner in charge, and to Jeff Fuller of the book, the structured finance specialist. And somebody realized, and obviously Mr. Grant couldn't remember how it emerged, but somebody realized that if you remove the solvency condition, you are removing subordination. Or you might be removing subordination. And that would create a regulatory issue by taking subordination away. And you can see that if we go back to supplemental 2, page 548. This is Mr. Grant's evidence about coming up with identifying this new problem. This top left-hand corner, 117, line 7. His problem was if the language had stayed in the form that we had last fall, that's the
So just hang on a minute, I'm
Sorry?
not with you yet.
Sorry, supplemental
548, yeah.
548, top left, page
Little
117.
page 117.
Line 7 says, if the language had stayed in the form that we last thought, and that's the intermediate one we just looked at, it would have said that the notes were subordinated senior creditors. but wouldn't have included a mechanism for that subordination to be effective. And the risk of violating the rules, he said it certainly wouldn't have been a typical way to achieve subordination. Simply saying that something is subordinated, senior creditors wouldn't commonly be used, wouldn't at that time now be commonly used for subordination. Another effective tool to achieve it. Having removed the solvency condition by that time, I'd realised we needed to find another way of achieving effective subordination. So, his perception, anyway, was that the conditionality affected subordination. And if you remove the conditionality, you risk at least removing subordination. We needed to find another way, and that's how this draft 2 evolved. So the first concern was to facilitate the deferral of interest. The second concern was to remove the solvency condition to solve Mr. Behal's tax problem. And the third concern was to find another way to deal with subordination, having removed the solvency condition. And the purpose of the amendments was to deal with all. So, Mr. Grant, as you then remember, produced what we call draft 2 to deal with the tax and subordination concerns. And that was sent to Lehman on the 12th of June at page 448. 448. Which we have, of course, seen and much been talked about. And this is where he expressly flagged that there were new changes for tax reasons. And to be clear, as we said, the original draft dealt with deferred interest. So that had all been done and dusted. This was a new draft with new changes, which were expressly to deal with tax sensitivities arising out of the issues raised. So, no question, this somehow not really matter, but for the locals behind the scenes, it was on the face of the email. As to what then was sent, sent everybody, Jackie Dolby, Harold Dave, who was a lawyer, Emily Upton, who we'll see later was one of the decision makers, Miss McMorrow, who was the in-house counsel, Anne Claude Nodell, partner, and Sophie Tomlinson. As for what was sent, you go to 458.
That's in the form that we now see, isn't it?
In unamended form, yes. This list of this. There's a further amendment at a different point later on. But what they were sent, having been told these new amendments dealt with tax considerations, they were then sent this, and on page 458, there's a whole new chapter of section 3 set out in blue, which identify the new changes to deal with the new issue. And that introduced, we submit, well, I'm right in this argument, we have got to this point, a whole new subordination regime in a winding up by reference to preference share. If I'm wrong in the argument about construction, we don't need to, so I must have, in the same way as assume that I'm wrong on the unamended note, we have to assume I'm right on the amended note. So, on the face of it, this produced a whole new regime by reference to preference share. Now, just points out, and this is passing, this was the product of collaboration within A&O. It was specifically, in Mr. Grant's contemporaneous record, to deal with ranking. If you go to page 499, towards the bottom of the page, 499, internal email from Mr. Grant, I think the 11th of June, 12th of June as well, he was trying to work out how to do this. And near the bottom is an internal email from Mr. Grant and Claude Moser, discussing, I think, a meeting we're going to have. He said, I've been having a lot of trouble on the notes since this morning because the tax comments are contrary to what we need for ranking. No question. What he was seeking to do was address ranking in these amendments. And we know that the way he did that was by using the preference share technique, which we've discussed, as a reference point for subordination. And if you go back, please, to 548. What he did was that he was looking for a different reference point, and he found one through the preference share technique.
You're now on page 118, are you?
Yes. 118, we talk about the solvency condition. Then he talks about his drafting. And we submit that was specifically done to achieve a ranking position. And for what it is, like this document, it was, even in his mind, intended to achieve, if you like, above and below in terms of ranking. So that's it, his intention was somehow to put a floor on it. That was contrary to his evidence. If you go to, supplementary bundle 1 again, tab 1, page 17. This also helps to explain, these are the first rectifications that the explanation notes. But at 117, this is Mr. Grant's written statement. And we take it up at 42, explaining how he got to this process of drafting. He said the new drafting adopts a tried and tested approach which had been used for upper tier 2 subordinated bonds. So preference share technique had been used by him as the means for subordinating upper tier 2. 43, the method was traditionally used for undated subordinated debt, which would have counted upper tier 2, and that's why we get notional holders. 45, the typical upper tier 2 did not change the debt into equity, it just stated that it ranked immediately above all issued equity. That's what the typical upper tier 2 preference share subordination provision holds, just above equity. But then and then he says he was doing this for lower tier 2, it's what he called a bespoke solution to deal with the issue. But if you then go back to 45. 45, the typical upper tier 2 does not change the debt into equity, which stated ranked immediately above all issues. Formulation I use from drafting amendments sought to apply and extend the notional preference share concept to lower tier 2 security. That's fine. But he then says at 46, sort of the page, the wording differed from the usual form of upper tier 2 security. Rather than ranking as if the note holder held a notional share, or a preferential right to return of assets for the holders of all classes of issued shares, the note holders themselves also ranked above holders of notional shares. So he's identifying the notional holder there. And he then concludes. We go further to page 19 and 52. The last sentence of 52. Whereas before the amendments, the conditions only described what ranked above the LBHI2 note, the amended conditions describe what ranks above the LBA Type 2 notes and also what ranks below them. Even his subjective intention in placing the preference share concept was to rank these notes above and below.
Right, would that be a convenient moment, Mr. Beltrami? If I say 2 o'clock rather than 5 past, will that inconvenience anybody? 2 o'clock.